So ukatangidza ukati iwo laptop yako disconnect situation
inongodelay nakiri inongodelay kusenda
azvingoitiki zvega
andisinzisa
is it not a process that happens automatically
yodi
kana ungoconnecta chero ukavhara laptop inongostream
zvoda ndikaseta kuti ndikavhara laptop anti haisleep but zvinoda kungotanga ndaseta abhozi nandakata naikirezvo.
Standing alongside the elected president, the elected parliament, and the courts. If they are subject to the constitution, as in every constitutional democracy, they must be then in accordance with the constitution, is the correct expression of that subordination. And the old wording, which cast the military as an independent upholder of the constitution in its own right, was the anomaly. The institution whose function is to uphold the constitution are the elected and appointed civilian institutions. The president takes an oath to uphold it. Judges take an oath to uphold it. Members of this house take an oath to uphold it. The defense forces protect the nation within the constitutional framework that those civilian institutions uphold and interpret. They are not a parallel constitutional authority. To suggest, Mr. Speaker, otherwise is to invite exactly the danger our history warns against. Nor is the constitutional anchor of civilian control removed by this clause, for that anchor was never Section 212. It is Section 208, which has required since 2018 that every member of the security services act in accordance with the Constitution and the law, that none act in a partisan manner, and that none further the interests of a political party. Section 208 is not touched by this bill. It stands entirely. Clause 16 simply harmonizes the language of Section 212 with the standard Section 208, or which with the standard Section 208 already sets, and in doing so, it reinforces Section 213 and 214, the provisions that place the deployment of our forces in the hands of the elected president, subject to the oversight of this parliament. The bill's own memorandum states this purpose plainly. The amendment is in 214. The civilian and constitutional control of the military is not weakened by clause 16. It is made textually consistent and thereby strengthened. Mr. Speaker, sir, allow me now to turn to consequential amendments. That is clauses 5, 6, 18, 19, and 22.
Point of privilege, Honorable Speaker. Point of privilege.
Mr. Speaker, sir, the bill closes with a section of clauses that align and complete the constitutional text, each following from a decision taken elsewhere in the bill.
Honorable Minister, just a minute. There's a point of order. Yes.
Yeah, Honorable Speaker, I want you to take note of a post that has been posted on our parliamentary platform.
You wanted to do what?
I want you to take note on a post that has been posted on our parliamentary platform, social media platform. It is saying Honorable Molokeli has crossed over to ZANU-PF. It's not true. They must respect. We have got Honorable.
Order, Honorable Member.
Yes, yeah.
Order, Honorable Member. Order. I thought you should be listening to what the Honorable Minister is saying, rather than being distracted by social media, which may not be accurate. The Honorable Minister, you know the truth. Thank you.
Thank you, Mr. Speaker, sir. Mr. Speaker, the bill closes with a section of clauses that align and complete the constitutional text, each following from a decision taken elsewhere in the bill, aligning with previous amendments to the Constitution or correcting an arrangement that experience has shown to be unsound. Clause 5 removes the word first before Vice President, a remnant of the running mate system this House set aside in Amendment number 2 of 2021. With that system gone, the word implied has no further work to do, and the text is best tidied out. Clause 6 aligns the rules of succession with the new method of election, so that a vacancy in the presidency is filled by the same constitutional pathway that fills the office in the first place. Clause 18 and 19 consolidate the work of the Zimbabwe Gender Commission within the Zimbabwe Human Rights Commission. Mr. Speaker, sir, I know this is among the most keenly contested proposals in the bill, and it deserves a careful answer rather than a slogan. Let me give the House the single most important fact, the one that critics do not engage. The constitutional commitment to gender equality does not reside in the Gender Commission, and it is not touched by this bill. Gender equality is a founding value of our Constitution, Mr. Speaker, under Section 3, which cannot be amended without a referendum. The right to equality and non-discrimination is entrenched in Section 56 in the Declaration of Rights. The rights of women are entrenched in Section 8. The state's duty to promote gender balance is in Section 17. Not one of these provisions is amended by so much as a word. They remain exactly where the founding framers of this Constitution placed them, justifiably in every court, in the land. What clauses 18 and 19 change is not the commitment, but the vehicle. The gender mandate is not abolished. It is written expressly and at constitutional level into the mandate of the Human Rights Commission in the amended Section 243. This is consolidation, not abandonment, Mr. Speaker. And it is the practice of many of the world's respected democracies. The United Kingdom, Australia, Canada, and New Zealand each pursue gender equality through an integrated human rights body rather than a standalone commission. Kenya combines its gender mandate with equality, disability, and minority mandates in a single body. The international instruments our critics cite, the Convention on the Elimination of Discrimination Against Women, the Maputo Protocol, the SADC Protocol on Gender, require appropriate and effective machinery for gender equality. Not one of them prescribes a standalone commission as the only permissible form. This reform places them where human rights are protected, at the center of human rights architecture rather than at its periphery. Clause 22 draws the curtain on the National Peace and Reconciliation Commission. This was, Mr. Speaker, from the outset, a transitional institution. When this House was created in 2013, it was given a defined 10-year mandate, a body built for a season, not for perpetuity. But Clause 22 does not abandon the work of reconciliation. It does the opposite. The duty of the state to promote national reconciliation, peace and unity is set out in Section 10 of the Constitution, which the bill does not touch, and that duty endures. What Clause 22 does is to carry the work of reconciliation out of a single time-bound commission into the permanent responsibility of the state, where it can be pursued through dedicated legislation, purpose-built for the task, or under the auspices of the Human Rights Commission. Reconciliation, peace building, and national healing are too important to be confined to one commission with a closing mandate. They must become enduring obligations of the state itself. That is what this clause secures. Mr. Speaker, I now conclude. Mr. Speaker, this bill is best understood not as an act of invention, but as an act of completion. When this nation gave itself a new constitution in 2013, it promised itself a modern, multi-party democracy built to deliver development and social progress. Yet it carried forward untouched two features fashioned for a country that no longer exists: an electoral cycle so short that the next campaign began the moment the last one ended, an institutional design left half complete, with mandates that overlapped and offices placed in quiet tension with one another. We know the price the country has paid: a generation of perennially contested elections, of capital that took flight, of confidence withheld, of potential left waiting on the next ballot. What this bill, Mr. Speaker, seeks to do is to recalibrate the architecture of our democracy so that it serves the work of governing and the task of development rather than the endless fighting of elections. And it does so for the institution and never for the individual. For the steadier season it creates belongs to the office and to the republic and to no person at all. Consider what the nation stands to gain: a disciplined and continuous season of government in which a program such as Vision 2030 can be carried through to completion, a calmer way of choosing its highest office, drawn from the settled practice of mature democracies such as Botswana and South Africa, which lowers the temperature of national politics and ties the executive to the confidence of the people's elected chamber, a cleaner and more trustworthy voters' roll, kept where the records of every citizen's life already live, boundaries drawn by a dedicated and expert hand and settled well before any contest, so that no one who runs the race also draws the field, a highest court able to speak with authority on the questions that matter most, institutions that are each clearer and stronger for having a single task they can discharge well, and a place, Mr. Speaker, and a place, once more, among the African and Commonwealth democracies whose tested practices these reforms reflect. This is the choice before the House, Mr. Speaker, between a constitution built for the endless electoral conflict and a constitution built for the long walk of development, between a republic that begins itself anew every few years and a republic, Mr. Speaker, permitted at last to finish what it starts. I do not ask, Mr. Speaker, this House to take a leap. I ask it to take a step, a measured step, a lawful step, an overdue step within the power this Parliament holds For what this bill offers, Mr. Speaker, in the end, is the one thing a developing nation can never buy back once it has been spent. It offers time. Time given to the office, not to the person, to the republic, and not to the moment. Time not to perpetually campaign, but to build. Mr. Speaker said, this bill is sound in its law. Mr. Speaker, it is principled in its purpose, inspiring in its aspirations, and it is overdue in its time. Mr. Speaker, therefore I commend the Constitution of Zimbabwe Amendment number 3 Bill HB 1 Bill of 2026 to this Honorable House, and I accordingly move that the bill be now read a second time. I thank you.
Before I put the question, I want to address myself to the issue raised by the Honorable Mshoriwa regarding Section 98, subsection 1E of our standing orders. In the case of Divine Mambi Ni Obe versus either you want to listen or you can go in peace outside. I'll repeat. The case is one of Divine Muhambi Niobe versus Parliament of Zimbabwe, CCZ 12/23. That's the citation of the case. The Constitutional Court clarified the scope and limits of the sub judice rule in relation to Parliament. The court held that the sub judice rule, whose purpose is to prevent interference with ongoing judicial proceedings, is not absolute. While Parliament must generally avoid discussing matters pending before the courts, this restriction cannot override constitutional obligations. Specifically, the court found that Parliament, through the Parliamentary Legal Committee, could not rely on the sub judice rule to delay or avoid its constitutional duty under Section 152 of the Constitution to examine statutory instruments. The rule must yield where strict adherence would frustrate constitutional mandates. It went on to rule that accordingly, the court concluded that standing orders incorporating the sub judice rule are subordinate to the Constitution, and Parliament is obliged to act even if related litigation is pending. In essence, the decision affirms that the sub judice rule is a qualified procedural restraint, not a barrier to fulfilling constitutional responsibilities. The question before the House is a motion by the Honorable Minister of Justice, Legal and Parliamentary Affairs that the Constitution of Zimbabwe Amendment Number 3 Bill HB 1 2026 be now read a second time. Is there any debate? Honorable Zobo.
On a point of privilege, Mr. Speaker, sir.
Who is speaking? I can't.
Honorable Hlachwai.
Yes, Honorable Hlachwai.
Thank you very much, Honorable Speaker. Honorable Speaker, I was going to request your office to favor this House with information